I was staring at the newly installed wrought iron gate blocking the only access road to my back 40 acres, when I realized my peaceful Saturday morning had just turned into a nightmare. The gate was massive, complete with an electronic keypad and a sign that read, "Private Property Silverbrook Estates, HOA Authorized Residents Only." The problem was that this road had been my legal easement for the past 15 years, the only way to reach the timberland I owned behind the fancy housing development. My name is Gregory Zimmerman, and I had bought my 120-acre property in rural Tennessee back in 2011, long before the Silverbrook Estates development even broke ground. My land was shaped like a boot, with 20 acres fronting on Old Mill Road where my house sat, and a long, narrow strip connecting to the back 40 acres of prime hardwood forest. When the developers approached me in 2014 about buying a portion of my land for their gated community, I negotiated carefully. I sold them 60 acres in the middle of my property for a good price, but I made damn sure the deed included a perpetual easement for a road through their development to access my back 40. That easement was recorded, notarized, and filed with the county. I had copies in my filing cabinet, and the title company had assured me it was ironclad. For years, everything was fine. The development went up, wealthy folks from Nashville bought their overpriced McMansions, and I drove my truck through their pristine streets twice a month to check on my timber and make sure no one was dumping trash or poaching deer on my back acreage. Then, the HOA got a new president named Patricia Hendricks. I first met Patricia 3 months ago when she knocked on my door on a Wednesday afternoon. She was probably in her early 50s, with that specific haircut that demanded to speak to managers everywhere, platinum blonde highlights, and enough jewelry to stock a small boutique. She smiled with too many teeth and handed me a clipboard. "Hello there. You must be Gregory. I'm Patricia, the new president of Silverbrook Estates HOA. I'm just going around meeting all our neighbors and making sure everyone is aware of our community standards." I looked at the clipboard. It was some kind of acknowledgement form about HOA rules and regulations. "I appreciate you stopping by, Patricia, but I'm not part of your HOA. My property predates your development." Her smile tightened. "Well, technically, Mr. Zimmerman, when you drive through our community, you are using our roads and should be held to our standards. I have noticed your truck is quite loud and sometimes kicks up dust on our freshly sealed pavement." "The easement gives me the right to use that road," I said, keeping my voice level. "It was part of the original sale agreement with your developer." "Yes, about that." Patricia pulled out another piece of paper. "The HOA board has been reviewing all the legal documents related to our community, and we believe that easement may have been improperly filed. We are consulting with our attorneys." A cold feeling settled in my stomach. "That easement is legal and binding. I suggest your attorneys look very carefully before you try anything." She gave me that fake smile again. "We will be in touch, Mr. Zimmerman. Have a blessed day." That was April. In May, I started getting letters. The first one informed me that the HOA board was investigating the validity of my easement claim. The second one, 2 weeks later, stated that I needed to apply for a special access permit to use the community roads. The third one demanded I pay a quarterly road maintenance fee of $300. I ignored all of them and called my attorney, Marcus Chen, who had handled the original property sale. Marcus reviewed the documents and confirmed what I already knew. "Greg, your easement is solid. It runs with the land, meaning it transfers with the property ownership, regardless of who owns what. The HOA has no legal standing to revoke it, charge you fees, or require permits. Keep those letters, though. If they try anything, we will need them for court." I kept them. I also installed a dash cam in my truck after the fourth letter arrived in June, which threatened enforcement action if I did not comply with their demands. Something about Patricia's tone in that letter made me nervous. On that Saturday morning in July, I found out what enforcement action meant. I stood in front of that gate for a solid 5 minutes, my coffee going cold in the travel mug. My phone showed it was 7:15 in the morning. I pulled out my cell and dialed the number on the HOA sign. A chipper recorded voice answered, "Thank you for calling Silverbrook Estates HOA. Our office hours are Monday through Friday, 9 a.m. to 3 p.m. For emergencies, please contact your local police department. For all other inquiries, please leave a message after the tone." I left a message, keeping it polite but firm. "This is Gregory Zimmerman. You have installed a gate blocking my legal easement at the north entrance to Silverbrook Estates. I need immediate access to my property. This gate needs to be opened or removed today. Call me back at this number." Then I called Marcus. He answered on the third ring, sounding groggy. "Greg, it is Saturday morning. They gated off my easement. I'm standing in front of it right now. There's an electronic gate with a keypad completely blocking the road." I heard rustling. Then Marcus was suddenly alert. "Do not try to force it open or damage it. Take photos, document everything. I will draft an emergency motion for Monday morning. This is easement interference, and it is serious. In the meantime, is there any other way to access your back 40? "No. That is the whole point. When I sold them that land, the easement was necessary because it is the only access. The rest of my back boundary is against state forest land, too rough for a road." "Okay, document it all. I will have papers ready to file first thing Monday. This is actually good for us in a way. They have just handed us a clear-cut case." I spent the next hour taking photos from every angle. The gate, the keypad, the HOA sign, the road stretching behind it that led to my property. I took video too, narrating the date, time, and circumstances. Then I drove around the perimeter of Silverbrook Estates, looking for any other way in. The development was built like a fortress, with decorative stone walls and landscaping blocking every potential access point, except the main entrance on the south side, which was also gated. The main gate had a guard shack. I pulled up and a young guy in a rent-a-cop uniform came out. "Can I help you, sir?" "I need to get through to access my property on the north side. I have an easement." He checked his tablet, frowning. "I do not have you on the access list. Do you have a resident code?" "I am not a resident. I own property behind this development, and I have a legal easement to drive through. Someone put a gate on the north road this morning." "I am sorry, sir, but I can only allow people on the approved list. You will need to contact the HOA office on Monday." "This is illegal. That easement is recorded with the county." He shrugged, looking uncomfortable. "I just work here, man. I do what they tell me. You want to leave your name and number?" I gave him my information, though I knew it would not help. As I drove away, I called the sheriff's department. The dispatcher took my information and said she would send a deputy out. Deputy Williams met me at the north gate 40 minutes later. He was in his mid-30s, professional, and listened carefully as I explained the situation and showed him the easement documents I always kept in my truck. "This does look legitimate, Mr. Zimmerman, but this is a civil matter, not criminal. The HOA is claiming they have the right to control access to their roads. You are claiming you have an easement that supersedes that. A judge needs to sort this out." "But they have blocked my access to my own property. That has to be illegal." "If your easement is valid, then yes, it is. But I cannot force them to open the gate based on documents you are showing me. They could be fake for all I know. No offense. None taken, but what am I supposed to do?" "File an emergency injunction with the court. If a judge agrees your easement is valid, they will order the gate opened. Until then, my hands are tied." I thanked him and spent the rest of the weekend fuming. Marcus worked his magic and had papers ready Monday morning. We filed an emergency motion for a temporary restraining order and preliminary injunction, asking the court to order the HOA to immediately restore my access. The hearing was set for Thursday afternoon. Tuesday morning, I got a certified letter from the HOA's attorney, a firm in Nashville called Whitmore & Associates. The letter stated that upon review, the HOA had determined my claimed easement was invalid due to being improperly filed, and that I was trespassing on private community property by using their roads. It demanded I cease all access attempts and threatened legal action if I continued. Marcus laughed when I forwarded him a copy. They have terrible lawyers. That easement was filed perfectly. The county recorder's office has it on record. It is on their property deed. It is on your property deed. This is going to be a slam dunk, Greg. They are just trying to intimidate you. Wednesday afternoon, I decided to do some investigating. I drove to the county recorder's office and pulled all the relevant documents. My easement was right there, crystal clear, recorded in 2014 as part of the sale transaction. I pulled the Silverbrook Estates HOA governing documents too, just to see what I was dealing with. That is when things got interesting. The HOA's covenants, conditions, and restrictions document, filed when the development was created, specifically acknowledged the existence of my easement. Section 12.4 stated, "An easement for property access exists for the benefit of parcel number 087456023, owned by Gregory Zimmerman, providing perpetual access through the community's northern roadway. This easement shall not be blocked, impeded, or interfered with by the association." They had known about it all along. It was in their own founding documents. I made copies of everything and called Marcus. They knew. Their own CCRs specifically protect my easement. That is perfect. Bring those copies to court tomorrow. This just went from a clear case to an absolute joke. The judge is going to rip them apart. Thursday afternoon, I met Marcus at the Wilson County Courthouse in Lebanon. The hearing was in Judge Sarah Patterson's courtroom, and she had a reputation for being no-nonsense and fair. Patricia was there with two other HOA board members I did not recognize, along with their attorney, a slick-looking guy in his 40s named Derek Whitmore. They sat on one side of the courtroom, looking confident. Patricia even gave me a little wave like we were friends meeting for lunch. Judge Patterson called the case. "This is case number 2026CV8847, Gregory Zimmerman versus Silverbrook Estates Homeowners Association. Mr. Chen, this is your motion." Marcus stood. "Your Honor, this is a straightforward case of easement interference. My client has a recorded, valid easement providing access through the defendant's property to reach his landlocked rear parcel. Last Saturday, the HOA installed a locked gate blocking this access. We are asking for an emergency order requiring them to restore access immediately." "Mr. Whitmore?" Judge Patterson looked at the HOA's attorney. Whitmore stood smoothly. "Your Honor, the HOA disputes the validity of this claimed easement. Our investigation has revealed irregularities in the filing, and we believe the easement was improperly granted. Further, even if it were valid, the HOA has a right to secure its community and regulate access for the safety of its residents." "Do you have evidence of these filing irregularities?" Judge Patterson asked. "We are still gathering documentation, Your Honor, but we believe—" "Mr. Whitmore, this is not a trial. This is a hearing on a motion for emergency relief. Either you have evidence the easement is invalid, or you do not. Which is it?" Whitmore hesitated. "We are continuing to investigate, Your Honor, but we have concerns." "That is a no." Judge Patterson turned to Marcus. "Mr. Chen, let me see your evidence." Marcus approached the bench with a folder. "Your Honor, here is the recorded easement from 2014, properly filed with the county. Here is the property deed for Mr. Zimmerman's back 40, showing it is landlocked except for the easement. Here is the deed for the Silverbrook Estates property, which specifically references this easement. And here," he placed another document on top, "is the HOA's own CCR document, section 12.4, which acknowledges the easement and specifically prohibits the HOA from interfering with it." Judge Patterson read through the documents, her expression darkening. She looked up at Whitmore. "Mr. Whitmore, are you aware your client's own governing documents protect this easement?" "Your Honor, we were not aware of that specific provision. Mrs. Hendricks did not mention, so you filed in opposition to this motion without even reading your client's CCRs?" Judge Patterson's voice could have frozen water. "This easement is clearly valid, recorded, and protected by the HOA's own rules. Why on earth would your client block it?" Patricia stood up. "Your Honor, may I speak?" "You may, but be aware you are under oath. State your name for the record." "Patricia Hendricks, HOA President. Your Honor, Mr. Zimmerman drives a loud, dirty truck through our beautiful community. It lowers property values and disturbs our residents. We have a right to maintain our standards." Mrs. Hendricks, "Mr. Zimmerman has a legal easement. Your personal opinion about his truck is irrelevant. Did you read your own HOA's governing documents before installing this gate?" Patricia's face flushed. "I skimmed them, but they are very long, and Did your attorney advise you before taking this action?" "We consulted with Mr. Whitmore's firm, yes." Judge Patterson looked at Whitmore. You advised your client to block a recorded easement that is specifically protected in their own CCRs? Your Honor, I was not personally involved until the motion was filed. This was handled by a junior associate who may have missed. Enough, Judge Patterson cut him off. I am granting the motion. The temporary restraining order is issued. Silverbrook Estates HOA is hereby ordered to immediately remove the gate blocking Mr. Zimmerman's easement or provide him with unrestricted access through the gate. This order is effective immediately. The preliminary injunction hearing is set for 30 days from now, but I will tell you right now, based on this evidence, it will be granted. Mr. Zimmerman, you are also entitled to file for damages and attorney's fees. I suggest you do so. This is one of the most clear-cut cases of easement interference I have seen. Patricia's mouth fell open. But, Your Honor. Mrs. Hendricks, I strongly suggest you listen to your attorney from now on, and I suggest your attorney actually read the documents before filing papers with this court. We are adjourned. Marcus and I walked out of the courthouse victorious. Patricia and her group huddled with Whitmore in the hallway, and I could hear Patricia's raised voice as we passed. This is ridiculous. He's not even part of our community. Why should he get to— Whitmore cut her off, his voice urgent. Mrs. Hendricks, please stop talking. The judge has ruled. If you do not comply immediately, you will be in contempt of court. By the time I drove back to Silverbrook Estates, a work crew was already there dismantling the gate. Patricia's BMW was parked nearby, and she stood watching them work, her arms crossed and her face like thunder. When she saw me, she stormed over. I hope you are happy. Do you have any idea what that gate cost? $15,000. The HOA dues are going up because of you. Patricia, this was always a bad idea. That easement is legal and has been since day one. You are ruining our community. Everyone is complaining about your ugly truck driving through. Then they can close their curtains. I have every right to access my property. This is not over, Gregory. I will find a way to stop you. Marcus, who had followed me over, stepped forward. Mrs. Hendricks, I would advise you to leave my client alone. Any further interference with his easement rights will result in additional legal action. The judge made herself very clear. Patricia glared at both of us, then turned and marched back to her car. She peeled out of the parking area, nearly clipping one of the workers. The gate was gone by evening. I drove through the next morning just to make sure, and the road was clear. A few residents watched from their yards as I passed, and I waved friendly. Most ignored me. For 2 weeks, everything was fine. I accessed my back 40 twice, checked on my timber, and drove back out without incident. The preliminary injunction hearing came and went. The HOA did not even show up, and Judge Patterson made the injunction permanent. Marcus filed a motion for attorney's fees and costs, which the judge also granted. The HOA was ordered to pay Marcus's fees, which came to about $8,000. I thought it was over. I should have known better. 3 weeks after the court ruling, I went to access my back 40 on a Thursday afternoon. The gate was gone, but there was a new problem. The HOA had installed speed bumps, not just a few. They had put speed bumps every 50 feet along the entire stretch of road leading to my easement exit on the north side. There had to be 30 of them, each one a massive rubber and asphalt monstrosity that would require slowing to nearly a stop to cross without damaging my truck's suspension. I called Marcus immediately. They installed speed bumps, dozens of them. It is going to take me an hour to get through to my property. That is still easement interference, Marcus said. It is more subtle, but it is the same thing. They are trying to make the easement unusable. We will file another motion. How much is this going to cost me? We will get fees again, Greg. Do not worry about it. They are just making it worse for themselves. Before we could file, I got a call from Patricia. Her voice was sugary sweet. Gregory, hello. I wanted to reach out personally about the speed bumps. The HOA board voted to install them for the safety of our residents, especially children who play in the area. I know they may slow you down a bit, but safety has to come first. Patricia, there are no children playing on that road. It is the back access road to the service gate. This is obvious retaliation. I am offended you would think that. This has nothing to do with you. It is purely a safety measure. Then why were they not there before the court case? We have been planning this for months. It just happened to coincide with the gate situation. Patricia, I am going to give you one chance to remove those speed bumps voluntarily. If you do not, I'm going back to court, and it is going to cost your HOA even more money. Sue away, Gregory. We have done nothing wrong. I hung up and nodded at Marcus. File the motion. The second hearing was 4 weeks later. Same courtroom, same judge. This time, Patricia brought her entire 7-member HOA board and a new attorney. Whitmore's firm had apparently dropped them after the first disaster. The new lawyer was a woman named Jennifer Bradford, who looked competent and annoyed. Judge Patterson reviewed our motion with a sour expression. We are here again. Silverbrook Estates, what part of do not interfere with the easement do you not understand? Bradford stood. Your Honor, the speed bumps are a legitimate safety measure for the community. They were not installed to interfere with Mr. Zimmerman's easement. They apply equally to all residents using that road. How many residents use that road, Ms. Bradford? I do not have the exact number, Your Honor. Mr. Zimmerman, how many houses are on that road? I stood. None, Your Honor. It is the back service road to a locked maintenance gate. Nobody lives there. The only people who use it are me and occasionally HOA maintenance vehicles. And Ms. Bradford, you are claiming this is about safety? Yes, Your Honor. Children sometimes play throughout the community. Judge Patterson looked at the photos Marcus had submitted. These speed bumps are installed every 50 feet. That is excessive even for a residential street. This is clearly designed to make Mr. Zimmerman's easement unusable. I am ordering them removed from the easement road. You can keep them on your actual residential streets, but the section covered by Mr. Zimmerman's easement must be clear. You have 1 week to comply. Patricia jumped up. Your Honor, those speed bumps cost $20,000 to install. Then you should have thought about that before putting them on an easement road, Mrs. Hendricks. Sit down. We won again, but I could see this was turning into a war of attrition. The HOA had money and time, and Patricia seemed personally obsessed with making my life difficult. The speed bumps came out, but 2 weeks later, they installed a new gate. Not on my easement road, but on the main south entrance. The only way to access the easement road was to enter through the south gate, drive through the community, and exit north onto the easement road. The new gate required a code to enter. Patricia sent me a letter. Dear Mr. Zimmerman, for security purposes, all access to Silverbrook Estates now requires entering a valid resident code at our south gate. As you are not a resident, you will need to be buzzed in by our security guard. Please call the security office at least 24 hours in advance of any planned visits to arrange access. Thank you for your cooperation. I called Marcus. Now, they want 24 hours notice before I can access my own property. That is the most creative one yet, Marcus admitted. They are arguing they have a right to gate their community for security, which is true. But requiring advance notice to use an easement is still interference. We will argue it makes the easement impractical. File again? File again. The third hearing was 2 months after the first. Judge Patterson was clearly losing patience. When she saw the case on her docket, she sighed audibly. Silverbrook Estates, you are back before me. Why am I not surprised? Bradford stood. Your Honor, the HOA has a legitimate interest in securing its community. The South Gate serves that purpose. Mr. Zimmerman's easement still exists. He just needs to be buzzed through the main gate to access it. Mr. Chen? Marcus stood. Your Honor, requiring my client to call 24 hours in advance defeats the entire purpose of an easement. He cannot access his property for emergencies. He cannot conduct routine inspections. The HOA is using the security gate as a backdoor method to control and limit his easement use. Mrs. Hendricks, Judge Patterson looked directly at Patricia. How many times has Mr. Zimmerman used his easement in the past year? Patricia consulted a notebook. Approximately twice per month, Your Honor. And in those 2 years, has he ever caused a security problem? Has he committed any crimes? Has he harassed residents? Has he done anything except drive through to access his own property? Well, no, Your Honor, but then why does he need to call 24 hours in advance? It is our policy for all non-residents. He is not a visitor, Mrs. Hendricks. He is an easement holder. That means he has a property right to use that road. I am ordering you to provide Mr. Zimmerman with his own access code for the South Gate with no requirement for advance notice. He gets the same access as your residents. Patricia's face went red. That is not fair. He does not pay HOA dues. He does not maintain. Mrs. Hendricks, my patience is exhausted. Provide him a code within 48 hours, or I will hold you personally in contempt. Not the HOA, you, personally. Do you understand? Patricia sat down hard, her mouth pressed into a thin line. I got the code 2 days later via certified mail. For exactly 2 weeks, I had unrestricted access. Then Patricia found a new angle. I was driving through the community on a Saturday afternoon when an HOA security vehicle pulled up behind me, lights flashing. I pulled over, confused. The security guard approached my window. He looked nervous. "Sir, I need you to follow me back to the guard shack." "What is this about?" "The HOA board wants to inspect your vehicle before you enter the back property." "Inspect my vehicle? For what?" "They say you might be dumping construction materials or hazardous waste on HOA property." I laughed. "That is absurd. I'm going to check on my timber. I have nothing in my truck but a chainsaw and some water bottles." "I'm just following orders, sir. Please follow me." I called Marcus right there. He answered quickly. "Greg? They want to inspect my vehicle before I can use the easement. They are claiming I might be dumping materials." I heard Marcus groan. "Do not consent to the search. Tell them you are exercising your easement rights, and any interference will be reported to the court. Record everything." I put my phone on speaker and set it on my dashboard, recording. "I am exercising my legal easement rights and declining this search. I am proceeding to my property." The guard shifted uncomfortably. "Sir, I have orders to block your access if you do not comply." "Then you are violating a court order. This conversation is being recorded and will be submitted to Judge Patterson." I drove forward slowly. The guard got back in his vehicle but did not follow. When I returned 2 hours later, Patricia's BMW was parked at the guard shack, and she was waiting with the guard and 2 other board members. She stepped in front of my truck, forcing me to stop. I rolled down my window. "Gregory, we need to talk about your constant harassment of this community." "Patricia, get out of my way. I am leaving. You have been through here twice this week. That is excessive. I own property here. I can access it as often as I want. Move." "The board has voted to limit easement access to once per month. Anything more is disruptive." I held up my phone, still recording. "You are violating the court order. Move or I am calling the sheriff." "You are trespassing on private property." "No, Patricia, I'm using my legal easement. Last chance." She stood there, arms crossed, glaring at me. I called 911. The dispatcher answered and I explained the situation, giving my location. Patricia's eyes went wide when she realized I was serious. She moved aside just as I saw the deputy's car turning into the community. Deputy Williams, the same officer from the original gate incident, arrived and took statements from both of us. He looked at Patricia with barely concealed frustration. "Madam, there is a court order giving this man easement access. You cannot block him." "He is harassing our residents." "How is driving through to access his own property harassment?" "He comes through all the time." "How often?" Deputy Williams looked at me. "Twice a week usually, sometimes more if I am doing timber work." "That seems reasonable for someone who owns 40 acres of timberland," the deputy said to Patricia. "Madam, if you keep interfering with his court-ordered easement, you could be arrested for contempt of court. I suggest you let him pass." Patricia looked like she wanted to explode, but she stayed silent. The deputy waited until I drove away, following me to make sure there were no more incidents. Marcus filed a motion for contempt of court, backed by my recording. The hearing was set for 3 weeks later. By now, we were in November, 5 months after the original gate incident. I had been to court 3 times, and the legal fees the HOA owed me were approaching $30,000. Judge Patterson's patience was completely gone. At the contempt hearing, she did not even wait for arguments. She looked at Patricia and said, "Mrs. Hendricks, approach the bench." Patricia walked forward, looking defiant. Judge Patterson leaned forward. "Mrs. Hendricks, I have given you multiple chances to comply with the law. You have ignored every order. You have wasted this court's time repeatedly. You have cost your HOA tens of thousands of dollars in legal fees, and now you physically blocked Mr. Zimmerman's vehicle. Why should I not hold you in contempt right now?" "Your Honor, I was just trying to protect our community. He does not belong there. He has a legal easement. How many times do I need to say this?" But it is not fair. He drives through whenever he wants. He does not follow our rules. He does not have to follow your rules. He is not part of your HOA. The easement predates your community. Judge Patterson took a breath, clearly trying to calm herself. Mrs. Hendricks, I am finding you in contempt of court. I'm imposing a fine of $5,000, payable personally by you, not the HOA. I am also issuing a restraining order. You are not to contact Mr. Zimmerman. You are not to approach him. You are not to interfere with his easement access in any way. If you violate this order, you will be arrested. Do you understand? Patricia's face had gone white. Your Honor, I cannot afford $5,000. You should have thought of that before ignoring my orders. Pay the clerk within 30 days. Next, I am ordering the HOA to pay Mr. Zimmerman's attorney fees in full, which now total $32,000. Furthermore, I am ordering the HOA to pay Mr. Zimmerman damages for harassment and interference with his property rights in the amount of $20,000. Finally, I'm putting the HOA on notice. Any further interference with Mr. Zimmerman's easement will result in additional contempt findings and potential criminal charges. Ms. Bradford, I suggest you educate your client about the law. Bradford nodded quickly. Yes, Your Honor. Patricia was crying now, tears of rage streaming down her face. This is not fair. He is destroying our community. Bailiff, please escort Mrs. Hendricks out. We are done here. The bailiff, a large man in his 50s, gently guided Patricia toward the door as she continued to protest. The other board members sat in shocked silence. I thought that would be the end of it. I was wrong. 2 weeks later, I arrived at the south gate to find the keypad smashed and the gate hanging open. Someone had vandalized it. The guard shack was empty. I drove through carefully, noticing several houses had yard signs that read, "No truck easement, protect Silverbrook." When I reached the easement road heading north, I found it blocked again, not by a gate this time, but by garbage. Someone had dumped dozens of trash bags, old furniture, construction debris, and even a rusted-out washing machine across the entire width of the road. I took photos and called Marcus. They have blocked it with trash. This is insane. Call the sheriff right now. This might be criminal. I called, and Deputy Williams arrived 20 minutes later with another deputy. They surveyed the mess, and Williams shook his head. This is illegal dumping. The HOA is responsible for maintaining this road. They need to clear it. Deputy, I think someone did this deliberately to block my easement. You think Patricia Hendricks did this? I do not know, but it is suspicious timing. Williams nodded. Let me make some calls. Over the next few hours, the situation escalated. The sheriff's department opened an investigation into illegal dumping. The HOA claimed they had nothing to do with it, that someone had vandalized their property. But security camera footage from a nearby house caught something interesting. The footage showed Patricia's BMW parked near the North Road at 2 a.m. 3 days earlier. The camera angle did not show the actual dumping, but it showed Patricia's car there for approximately 40 minutes in the middle of the night, which she had no legitimate reason to be. Deputy Williams brought Patricia in for questioning. She denied everything at first, but when confronted with the camera footage, she broke down. She admitted she'd been so angry about the court's ruling and the fine that she paid some day laborers to dump trash on the easement road. She thought if she made it look like random illegal dumping, no one could prove it was her. Patricia Hendricks was arrested and charged with illegal dumping, criminal mischief, and violating the restraining order. She was also sued by the HOA for the costs of cleaning up the mess and for bringing liability on the association. The HOA called an emergency meeting and voted to remove Patricia as president. They elected a new president, a retired engineer named Robert Morrison, who seemed reasonable. Robert called me personally to apologize. Mr. Zimmerman, I want you to know that Patricia's actions do not represent the community. Most residents do not even care that you drive through. This whole thing was her personal crusade. We have cleared the dumping, and I guarantee you will have no more problems with your easement. I appreciate that, Robert. I never wanted any of this. I just want to access my land. I understand completely. We are going to put it in writing. The HOA board is passing a resolution formally acknowledging your easement and committing to never interfere with it. You will get a copy for your records. Patricia pleaded guilty to the charges in January and was sentenced to 6 months of probation, community service, and restitution for the cleanup costs. She moved out of Silverbrook Estates shortly after, selling her house at a loss to get away from the community that now blamed her for their legal troubles. The HOA paid me the $52,000 in attorney's fees and damages in February. I used some of it to install my own small access gate on my back 40, just to have a secondary exit if needed. I also graded a section of my front acreage and built a small pole barn for storing equipment, so I did not need to drive through Silverbrook quite as often. Robert Morrison turned out to be a good HOA president. He streamlined the rules, got rid of a lot of Patricia's petty enforcement policies, and generally made the community more pleasant. He even invited me to an HOA barbecue in the spring as a goodwill gesture. I went, met some of the residents, and found that most of them were normal people who had been horrified by Patricia's behavior. One resident, a retired teacher named Margaret, apologized profusely. "I am so sorry for what Patricia put you through. She told the board you were some kind of troublemaker who was trying to take advantage of the community. We did not realize you had a legitimate easement. She manipulated a lot of people." "No hard feelings," I told her. "I get that people want to protect their neighborhood. Patricia just took it way too far." By summer, things had completely settled down. I accessed my back 40 regularly, and no one bothered me. The HOA maintained the easement road in good condition, actually better than before since Robert made sure their maintenance crew included it in their regular schedule. I even helped the HOA out once when a severe storm knocked down several trees. A few had fallen across the easement road, and I brought my chainsaw and tractor over to help clear them. Robert was grateful, and it helped build goodwill with the community. The legal saga had lasted nearly a year, from July to May, and had cost the HOA approximately $70,000 in legal fees, damages, cleanup costs, and Patricia's vandalism. It had cost me nothing except time and stress since the court ordered them to pay my attorney's fees. Marcus Chen framed a copy of Judge Patterson's final contempt order and hung it in his office as an example of what happens when HOAs ignore the law. He sent me a photo of it with a text that read, "Thanks for the easiest money I have ever made. Next time someone wants to mess with your property rights, please call me immediately." The whole experience taught me several important lessons about property rights, easements, and dealing with unreasonable people in positions of minor authority. The most important lesson was documentation. Every photo I took, every recording I made, every letter I kept became critical evidence. Without that documentation, the case would have been much harder to prove. I also learned that sometimes people get so fixated on being right that they lose all sense of perspective. Patricia could have saved herself and her HOA tens of thousands of dollars if she had just accepted the reality of the easement from the start. Instead, her pride and stubbornness turned a non-issue into a year-long legal battle that destroyed her reputation and cost her personally. The back 40 acres are doing well, by the way. I had a forester come out and evaluate the timber in March, and he estimated I had about $200,000 worth of mature hardwood ready for selective harvest. I'm planning to log about 20% of it next winter, which will give me a nice profit while keeping the forest healthy and sustainable. I still drive through Silverbrook Estates twice a week on average. Sometimes residents wave as I pass. The security guard at the south gate knows me by name now and jokes about my VIP access. The whole community seems more relaxed without Patricia's constant rule enforcement and drama. Judge Patterson retired last month, and the local bar association held a dinner in her honor. Marcus invited me to attend, and I did. I got to thank her personally for her handling of my case. "Mr. Zimmerman, your case was actually one of my favorites," she told me. "The law was completely clear, and it was satisfying to see justice done properly. I just wish Mrs. Hendricks had not made it so difficult. She seemed like a very unhappy person." "I think you are right about that, Your Honor, but it worked out in the end." "It did. And I hope other HOAs learned a lesson from it. Easements are serious property rights, not suggestions." The case even got some local media attention. A reporter from the Lebanon Democrat newspaper wrote a story about it titled, "HOA President Arrested After Year-Long Easement Battle." It ran in April and generated quite a bit of discussion on social media. Most comments sided with me, though a few people defended HOAs as necessary for maintaining property values. One commenter wrote, "HOAs are out of control in Tennessee. They think they can do whatever they want. Good for this guy for standing up to them." Another wrote, "As an HOA president myself, Patricia Hendricks is an embarrassment. We exist to maintain common areas and enforce reasonable rules, not to harass property owners with legal easements. She deserved everything she got." The story apparently circulated in HOA management circles as a cautionary tale. Marcus told me he got 2 new clients specifically because they had read about my case and wanted an attorney who understood easement law. In June, the HOA held their annual meeting and voted to rename the easement road. They called it Zimmerman's Way, as a gesture of reconciliation. Robert said it was important to acknowledge that I had always been reasonable and patient throughout the dispute, and that the road had essentially been my access route for over a decade. I thought it was unnecessary, but I appreciated the gesture. My girlfriend, Wendy Harper, thought the whole thing was hilarious. We started dating in March, a few months after the court case ended. She is a paralegal at a different law firm in Nashville, and when I told her about my HOA battles, she could not stop laughing. "Let me get this straight," she said over dinner one night. "This woman paid $5,000 in fines, got arrested, lost her position, and had to move, all because she was mad about your truck driving through her neighborhood. That about sums it up." That's the dumbest thing I've ever heard. Why do people care so much about stupid stuff like that? I have no idea, but I'm glad it's over. Wendy came out to see my back 40 in April, and she fell in love with the property. She grew up in rural Kentucky and appreciated good timberland. She also thought it was funny that I now had a road named after me. "You are famous in HOA circles," she joked. "Gregory Zimmerman, easement warrior. I prefer property rights advocate." Same thing. We got engaged in August, and we are planning a small wedding next spring. We are talking about building a cabin on the back 40 eventually, something simple and rustic where we can get away from the city. The timber harvest should provide plenty of money for that project. I still own my house on the front 20 acres, and I'm planning to keep it. The property value has actually gone up since the Silverbrook Estates development brought more people to the area. I have had a few offers from developers who want to buy the whole parcel and build more houses, but I'm not interested in selling. This land has been in my family for 3 generations, and I plan to pass it on to my kids someday. The whole experience with Patricia and the HOA made me appreciate my property rights even more. It is easy to take them for granted until someone tries to take them away. The fact that I had a recorded legal easement made all the difference. If I had tried to access that property without proper documentation, I would have been out of luck. I've since become something of an advocate for property rights in Wilson County. I spoke at a county commission meeting in September about the importance of respecting easements and ensuring that HOAs do not overstep their authority. Several commissioners thanked me afterward and said they were looking at ways to strengthen easement protections in the county code. Marcus and I also put together a guide for rural property owners about protecting easement rights when selling land to developers. It covers what to include in easement agreements, how to ensure they are properly recorded, and what to do if someone interferes with your easement. We made it available for free online, and it has been downloaded over 5,000 times. The guide includes a section specifically about HOAs and how to deal with them. It emphasizes documentation, knowing your rights, and not backing down when you are legally in the right. It also includes excerpts from my case as examples of what not to do if you are an HOA and what to do if you are a property owner facing interference. Looking back on the whole saga, I am glad I fought it. It would have been easier to give up, to try to negotiate some kind of limited access agreement, or to just sell the back 40 and be done with it. But that would have meant letting Patricia and her HOA take away my legal property rights. It would have set a bad precedent and encouraged other HOAs to try the same tactics with other property owners. By standing firm and taking it to court, I not only protected my own rights, but also established case law that will help other property owners in similar situations. Judge Patterson's rulings are now on record and can be cited in future easement cases. That is worth something. The financial outcome was also good. The $52,000 in damages and attorney's fees more than covered my time and stress. The HOA's insurance company actually paid most of it, though their premiums went up significantly afterward. I heard through Robert that the insurance company required the HOA to implement new training for board members about property law and legal compliance. Patricia's arrest and conviction also sent a strong message that easement interference is not just a civil matter. If you deliberately block someone's legal property access, you can face criminal charges. That is an important deterrent for future would-be HOA tyrants. I sometimes wonder what Patricia is doing now. I heard she moved to Florida and bought a condo in a building with no HOA. Maybe she learned her lesson, or maybe she is down there finding new things to be angry about. Either way, she is not my problem anymore. Wendy and I drove through Silverbrook Estates last weekend on our way to check on the back 40. The community looks nice in the fall, with the trees changing colors and people decorating for Halloween. A few kids were playing in a front yard, and they waved as we passed. I waved back. "It is weird to think this place caused you so much trouble," Wendy said. "It seems so peaceful now." "That is because Patricia is gone. One toxic person can poison a whole community." "True, but it takes good people like Robert to fix it." "Also true." We spent the afternoon walking the timberland, marking trees for the winter harvest. The forester is coming next week to finalize the plan. We should start cutting in December when the ground is frozen enough to bring equipment in without tearing up the forest floor. The timber money will go toward building our cabin. We have the plans drawn up already. A simple 2-bedroom log cabin with a big porch overlooking the hollow, a stone fireplace, and a small barn for storage. Nothing fancy, just a peaceful place to get away from the world. As I walked through those woods with Wendy, looking at the massive oaks and hickories that have been growing for over 100 years, I felt grateful that I fought for my rights. Grateful for the legal system that protected those rights. Grateful for Marcus and his skill as an attorney. Grateful for Judge Patterson and her no-nonsense approach to the law. And grateful that I live in a country where property rights still mean something, where a regular person can stand up to an organization and win if the law is on their side. The back 40 represents more than just land and timber to me now. It represents the principle that rights matter, that documents matter, that standing up for yourself matters. Patricia tried to take that away from me because she thought her rules and her community standards were more important than my legal property rights. She was wrong, and the courts proved it. I think about all the people who face similar situations and do not fight back. Maybe they do not know their rights. Maybe they cannot afford an attorney. Maybe they just get tired of the stress and give in. I was lucky to have clear documentation, a good attorney who worked on contingency, and a judge who understood the law. Not everyone has those advantages. That is why I continue to speak out about property rights and easement law. That is why Marcus and I made our guide freely available. That is why I agreed to have my story shared in the newspaper. If my experience helps even one person stand up for their rights when an HOA or any other organization tries to push them around, then all the stress and frustration was worth it. Wendy squeezes my hand as we walk back toward the truck. The sun is setting, casting long shadows through the trees. In the distance, I can hear traffic on the highway, but out here, it is quiet and peaceful. This is my land, earned and paid for, protected by law, and it will be here long after I am gone. We drive back through Silverbrook Estates as the streetlights come on. The gate opens automatically with my code, the same access any resident has. The road is smooth and well-maintained. No one blocks my path. No one harasses me. I drive through like I have every right to do because I do. That is what easements are all about, the right to pass through someone else's property to reach your own. It is a concept that goes back hundreds of years in common law, and it exists because sometimes access is more important than absolute control. The people who originally owned the land that became Silverbrook Estates understood that when they sold me the easement. The developers who built the community understood it when they included it in the HOA's founding documents. Patricia Hendricks refused to understand it, and it cost her everything. As we exit the north side and turn onto the county road that leads back to my house, I look in the rearview mirror at the fancy houses and manicured lawns fading behind us. It is a nice community, really. The people are friendly, the houses are well built, and the common areas are beautiful. It just needed better leadership, someone who understood that being an HOA president does not make you a dictator. I pull into my driveway as the last light fades from the sky. My modest farmhouse sits on its foundation, the same place it has been for 70 years. It needs paint and the roof could use some work, but it is mine, free and clear. Behind it, stretching back through forest and field, are my 120 acres, connected by a legal easement that no one will ever take away. Wendy and I sit on the porch swing, watching the stars come out. She leans against my shoulder, and I put my arm around her. We do not talk much, just enjoy the quiet evening and the satisfaction of a good day's work. Tomorrow, I will probably get some minor task done around the property. Maybe fix the fence along the south pasture, or clean out the barn, or split some firewood for winter. Regular things that property owners do. And if I need to access my back 40, I will drive through Silverbrook Estates like I always have, exercising my legal right to use the easement that was properly recorded, legally binding, and protected by law. Patricia Hendricks tried to take that away from me, and she failed. The legal system worked exactly as it should have. The court protected my property rights, punished the interference, and made me whole again. That is all any property owner can ask for. Justice, according to the law, fairly applied. As I sit there with Wendy, planning our future cabin and our life together, I realize that this whole experience taught me something important about America and property rights. Despite all the frustrations and challenges, despite HOA presidents who abuse their power and try to push people around, the system still works. If you know your rights, document everything and stand your ground, justice can prevail. The easement to my back 40 is secure now, protected by multiple court orders and backed by settled case law. No future HOA president will ever be able to do what Patricia tried to do. The road is mine to use, forever, running with the land. That is the power of property rights in America, properly understood and legally enforced. And that is worth fighting for.